The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Please be seated. All right, we will begin with the Jacob Doe versus University of North Carolina. And Ms. Smith, pleased to hear from you.
Thank you, Your Honor. Good morning, and may it please the court. My name is Lindsay Smith. I'm with the North Carolina Attorney General's Office, and I represent the 12 defendants appellants in this appeal. I'm joined at counsel table by my colleague, Nick Brode. Your Honors, the plaintiff appellee in this case was accused of sexual assault by 4 of his fellow female students while he was a student at the University of North Carolina at Chapel Hill. He received the full panoply of procedural protections that the university provides under its sexual harassment and Title IX policies, which included a lengthy investigation into all 4 complaints, the opportunity to review written investigation reports, and a separate evidentiary hearing on each complaint. He was found responsible for 2 of the 4 complaints and was expelled from UNC.
Let me ask you about the panoply of benefits and rights that were accorded to the plaintiff in this case. His allegations are that one of the complainants, row number 2, withdrew her complaint, but he wasn't informed of that for 7 months. He took a voluntary polygraph without being told what the specific charges were against him. In the row number 1 hearing, the complainant was allowed to leave, and her attorney was who received cross-examination in her place. And in the row number 4, no cross-examination was allowed. That seems like an odd due process system of events.
So, Your Honors, I'd like to take maybe each one of those in turn. With respect to what plaintiff alleges is the withdrawal of the complaints by row 1 and row 2, what the complaint alleges is that they informed the EOC office that they did not want to move forward with the complaints. I don't think there's an allegation that they formally withdrew the complaints, but regardless, they were both complaints under the Title IX policies, and under those policies, the university has the obligation to review the reports and decide whether it needs to move forward with an investigation regardless of whether those complaints. That's all well and good,
but what about the party on the other side? They have no right to know of that?
There is nothing, as far as I'm aware, Your Honor, in the Title IX policies that requires notification to the policy, excuse me, to the responding party that reporting parties have decided not to participate in the proceedings. Now,
well, even if we assume that we're correct for Title IX purposes, how is that correct for due process purposes?
well, so this court, Your Honor, has clarified that what due process requires in a student disciplinary proceeding is notice of the charges, an evidentiary hearing, and an opportunity to provide a defense. And that's exactly what happened here, Your Honor. The plaintiff
Well, how
received.
can you provide a defense if you can't cross-examine the complainants?
So this court has specifically noted that cross-examination has never been required in a student discipline context, Your Honor.
Well, it may, we have said in the Virginia Tech case, you're quite right, that it's not required, but it's not forbidden either. And the question that I have is, we're dealing here with an issue that turns on credibility. And a lot of these sexual assault cases are questions of he said, she said, and the rest. And if something turns on credibility, you would think cross-examination was one of the best tools we have for testing credibility. And in addition, not only is this a case that turns on credibility, but you have a situation where a sanction could be imposed that simply could ruin this plaintiff's life. We're not talking about a mild suspension or a reprimand or something. We're talking about expulsion from the university, and not only expulsion from the university, but expulsion from the entire UNC system. And this is going to be on this individual's record, and so where you have a case that turns on credibility and you're imposing the most severe of all sanctions, wouldn't cross-examination wouldn't it occur to you that cross-examination would be important in getting at the truth of the allegations? And Row 4 had no cross-examination at all. And Row 1, in the middle of the cross-examination, decided to leave the room and turn it over to the attorney, which is the oddest kind of cross-examination I've ever heard, to have a witness leave and have the attorney take the witness stand. And so, yeah, this is not a criminal trial, and I realize that cross-examination is not invariably required, but might it not have been a good thing in this kind of situation where you're just imposing a draconian sanction and you on a matter which turns on credibility? Wouldn't your instincts have been to give the defendant in the proceeding a fair shot at cross-examination?
So, Your Honor, a couple of responses to that. I think the first is that in this particular case, there was no, to the extent that there were reporting parties and witnesses who participated in the hearing, the plaintiff was not denied the opportunity to cross-examine. I mean, I think as you recognize, Row 1 did participate in the hearing for an extensive period of time. She presented herself for questioning from the panel as well as from plaintiff's counsel.
How long did the cross-examination of Row 1 go on before Row 1 left the room?
So it's not in plaintiff's allegations in the complaint, but my understanding is that she submitted a cross-examination for approximately 40 minutes before she left the
We're talking
hearing.
about an immunity case here. Are the due process violations alleged here clearly established under our university-specific case law?
And I think that's my second point to Judge Wilkinson, to the questions about cross-examination, is that we are on a qualified immunity, in a qualified immunity context. And I think particularly here, because of this court's holdings in the Virginia Tech case, as well as reiterating it in the Citadel case, that cross-examination is not required in the context of a student discipline proceeding, that cross-examination, that was not clearly established in this particular case. I think that the same is true for the other due process allegations or violations that plaintiff has alleged, specifically the lack of notice, as well as the evidentiary concerns that the plaintiff has alleged with respect to the Row 4 hearing. And so what we have said is,
Well, what would be the circumstance under your view where the actions of the deliberative body would be so egregious that due process would be violated?
I'm sorry, I'm not sure I understand the question, Your Honor.
Well, if you're pursuing qualified immunity, it's not clearly established, then it almost means that we'll go forward in infinity and it will never be established. So what I'm asking you is there a circumstance where the actions of the deliberative body would be so egregious that due process, for instance, cross-examination, or the actual appearance of the complainant would be required?
So I'm not sure, so I think there are certainly instances in which due process would be violated even in the qualified immunity context. I mean, again, this court has established that due process requires, in the student discipline context, notice of the allegations against the student, a hearing, and an opportunity to provide a defense. I mean, I think if a student did not receive an evidentiary hearing, it is certainly clearly established that in this particular context, a student is required to receive an evidentiary hearing. We do not believe, however, Your Honor, that it is clearly established that cross-examination was required, but I think the other point that I would make here is that to the extent that the policy said that a plaintiff should have the ability to cross-examine witnesses who appeared at the hearing and participated in the hearing, that did occur here, Your Honors. And
Wouldn't it be the purpose of this court, if it saw something egregious in the process of, in due process proceedings that were not clearly established, that we, going forth, could say that there, in order to achieve due process in the future, there must be the right of cross-examination?
That is correct, Your Honor, and of course this court could decide and could decide at this point if it wanted to say cross-examination is required, but I think for qualified immunity purposes, it was not clearly established at the time that this hearing
The
occurred.
qualified immunity would protect the defendants against any kind of damages. You wouldn't, it's a defense, qualified immunity is a defense to damages.
That's correct, Your Honor.
But this individual, there are some suits for the damages, I realize, which qualified immunity might kick in, but his chief interest seems to be equitable and injunctive relief. And he wants, above all, I would think, reinstatement. In light of ex parte Young, I'm not sure that, I mean, I think the qualified immunity speaks to damages. And there's a fair point on that, but the suit for equitable relief under ex parte Young, I think, could still go forward, because this was a 12B6 dismissal. And in the course also of deciding the qualified immunity question, even if we were to agree with you on that, Judge Floyd makes a very good point that we could underscore the fact that this kind of hearing, while it may not have been clear in these particular circumstances, going forward, the idea that somebody can be expelled from an entire school system without any kind of, without the most meaningful test of credibility, it just doesn't make sense. You might suspend somebody for a week or reprimand somebody, and cross-examination might not be required. Because I recognize it takes some courage to come forward with these complaints, and the cross-examination is never pleasant. But we can't have rump proceedings that are ruinous to lives. That's the problem, and the district court found not only was a problem with cross-examination, but that there were problems of notice. For example, they got the date wrong. Well, that's okay because indictments are all often framed on or about, and I understand that language. But here you have someone that's saying, look, we had a consensual relationship. I think this was row one. We had a consensual relationship for a good period of time. But then he's researching what happened on a particular date. And he's asking himself, well, wait a minute, we had obviously a consensual relationship. Did I do something wrong on this particular date? And he's looking into the particular date and what they were doing. And so the district judge is saying, you know, that's problematic too. It's not just the cross-examination here. And these hearings have got to be meaningful when somebody's life is somebody's future reputation and life is at stake. And there's clearly a liberty interest here. And I'm just, what do you have to say about the other considerations in addition to the absence or the truncated cross-examination? What do you have to say?
Your Honor, I see my time has expired. Do
Yeah, would you want to do that on rebuttal?
I'd prefer, if Your Honor would permit me, I'd prefer to respond now.
I'll let you do it now. You can do it on rebuttal. Which would you prefer?
I'll respond now, Your Honor. I mean,
Okay.
I think with respect to the notice allegation, I think one thing that's very important here to know is that plaintiff never alleges that he was deprived of notice of the substance of the allegations. He was made aware that he was alleged to have had sex with row one without her consent while she was sleeping or incapacitated after having drunk alcohol at a fraternity event, particularly alcohol that was like peppermint schnapps flavored beverages. This was a specific event that plaintiff was aware that happened on a particular night. So it was not that this was one in many different events that happened. This was a specific event, and he was aware of the substance of those allegations, Your Honor.
I hear you on that, but the district court made the point that there could be one infirmity here or something that wasn't quite right, but you wouldn't condemn the whole hearing because of that. But the district court was concerned about several things that in the totality made this something less than fair. And it would seem to me that as far as the injunctive relief is concerned, this person is entitled to a full and fair hearing that gives him a chance to do what I think is his major goal, which is to at least have a shot at saying, I deserve to be reinstated.
So, Your Honor, I'll make one point about the injunctive relief, and then I'll reserve the remainder of my time for rebuttal. On the injunctive relief, Your Honor, we do believe that there were not due process violations here. I mean, I think that for the ex parte Young argument that there was no ongoing violation of federal law. And because of that, because the allegations that plaintiff has alleged did not rise to the level of due process violations, that in this particular case, the official capacity claims that Your Honor references that would provide a plaintiff with the ability for injunctive relief should be entitled to sovereign immunity as well. I would like to reserve the remainder of my time for rebuttal, but I'm happy to answer any other questions that Your Honors have at this point.
Let me ask my co-panelists if they have. Judge Agee?
On a different topic, I do have one question. As I understand it, you made a 11th Amendment argument for immunity, is that right? And the district court did not agree with you at that point. because of the language in the state statute about body politic. Was there any discussion in the district court of the Ramdita factors, which we would normally look at in this circumstance?
No, Your Honor. In the district court, there was no discussion of those factors. And we would say, Your Honor, that there was no reason for a discussion of those factors because this court has previously held in the Huang case that the University of North Carolina is entitled to sovereign immunity as a state agent. In the Maryland Stadium Authority.
So you say that's res judicata as to the issue?
No, Your Honor, we would say that it's a question of law that has been settled and established by this court already. And so for that reason, there was no reason to go through those particular factors. I would also say that to the extent that plaintiff claims that there was no discussion of the arm of the state analysis, that they've only raised that particular argument on appeal and did not raise it in the district court.
Well, the district court only raised the point sui sponte, so it hadn't come up before.
Correct, Your Honor. But I think what we would say is that because this court has previously decided that the University of North Carolina is a state agent entitled to immunity, there was no reason for the district court to go through that analysis, nor was there any reason to revisit that determination at this point. And so because of that, Your Honor, the district court is, the university defendants were entitled to sovereign immunity on the claims, the due process claims in federal court. Now, I will say to that point about the state statute that states that the university is a body politic and corporate. Huang itself, in a footnote, specifically noted that these types of that there's nothing in 116.3, North Carolina General Statute 163.
I think I understand your answer.
Okay, thank you, Your Honor. If there are no other questions, I'm happy to sit down.
You've run over a little bit, but that's because of our long questions, so you're going to have your time for rebuttal.
Thank you, Your Honor.
Even so, you've reserved it and you're going to get it.
Thank you, Your Honor. I appreciate it.
Mr. Miltenberg, I'd be happy to hear from you.
Good morning, Your Honors. Good morning. Andrew Miltenberg, Nessenoff Miltenberg, together with my colleague Tara Davis, on behalf of Jacob.
Can you put the microphone real close to you so we can
Yes.
hear what
My height usually
what
makes-
both sides have to say is
Certainly.
important?
Certainly. Andrew Miltenberg, together with my colleague Tara Davis. Your Honors, we have both reserved time today, myself to address Title IX issues, Ms. Davis to address qualified and sovereign immunity issues, if that's acceptable to the bench.
I'd like to ask you on the qualified immunity point. We have this statement in the Virginia Tech case that qualified immunity, that cross-examination said we have never required cross-examination. And when you look at the cases around the country on this point of cross-examination, they're all over the place. I mean, there's some circuits that require, and in the Virginia Tech case, our court acknowledged the circuit split. And so you get you get something like 3 circuits saying cross-examination is required, and 3 circuits saying it's not. And then even of the circuits that say it is required, they allow the hearing officer perhaps to do the cross-examining. So you've got a legal picture that's all over the place. And you've got this statement in the Virginia Tech case about the place of cross-examination. So as far as damages are concerned, and a qualified immunity defense is a defense for damages. It's not applicable to ongoing equitable relief. But why wouldn't this be a case given the riptides and cross currents in the law for qualified immunity to apply.
Can I have Ms. Davis address that question, Your Honor?
No, you're up here.
Okay. I think that the cross-examination issue, while it appears to be in flux throughout the country, is less so on the more recent cases, and especially subsequent to January 9th's decision, where we go back to the 2020 regulations for Title IX, in which a live hearing and cross-examination was an essential, critical part of the Title IX hearings. That's the regulations that we're now back at after the 2024 regulations.
What they're saying is that apart from the cross-examination issue, they're saying you still got a lot. It was a fair proceeding, all things considered. That at least is their contention. They say there were interviews with plaintiffs, the reporting students, other witnesses. You got the opportunity to respond to the draft investigation reports. There were 4 separate evidentiary hearings with, and each had a different panel. You were represented by counsel, and they say you got a lot here in terms of notice and different hearings and different boards, and you had a chance to make your views very clearly known. What do you say about that? That in its totality, they're contending this was fair?
Well, not only has UNC violated almost every aspect of the 2020 regulations as it relates to this matter, which is controlled by the 2020 regulations, and we're going back to those, as I mentioned, but there are a significant amount of specific instances that...
So let me be sure I understand where you're going. Are you saying the regulations impact qualified immunity?
No, I was solely talking about cross-examination.
Right, but the cross-examination issue relates to qualified immunity, doesn't it?
It does, and not only does it relate to the qualified immunity, but qualified immunity, by definition, requires some amount of understanding of what all the defendants did or did not do.
Right, but first, help me understand the regulations. Where are they coming into this, or do they?
As far as qualified immunity? Or
Yes,
as, they only bear on qualified immunity to the extent that any particular person or defendant violated one of the regulations.
But I'm asking you, Judge Agee is absolutely right. The cross-examination issue resembles bears on qualified immunity. And I'm saying, is it fair to hold these folks liable for damages? I'm not talking about equitable relief and reinstatement and expungement and the other things that I understand are important to you and that you're seeking vindication upon. I'm not talking about your request for ongoing injunctive relief. That seems to me to be pretty close to ex parte Young. But I'm talking about the immunity that you are asserting, that the other folks are asserting with respect to the hearing. And is it fair to hold these individuals liable for damages, given the fact that the courts are all over the place and our court has said it's not invariably required? This is, I'm just wondering whether a decent course in this case would be to let your claims for equitable relief proceed, give you your shot at reinstatement, make it clear in the qualified immunity analysis that in the future, this is going to be clearly established that this kind of cross-examination should be required under circumstances akin to this one. But the final step, you could win a lot, but at the final step, is it fair to hold these folks liable personally for damages when the law hasn't given them clear notice? You're talking about the need for clear notice, and I couldn't agree with you more. But they want clear notice too. And so if you say I'm sympathetic to you on the one thing, but it just seems to me that you might actually think that, hey, my opponents are entitled to clear notice too, before they're strung up for damages. That's what I'm saying. And that doesn't cut off it doesn't seem to me it doesn't cut off your claims for ongoing injunctive relief. And I would, if I were you, I would think that getting reinstated would be a paramount concern.
Your Honor, I don't want respectfully to get too deep into the hole of suggesting just cross-examination was violated. The violations in this case, procedurally and otherwise, are so compelling and significant that, yes, I do believe this may be a case where the individuals should be held responsible. These were thoughtful decisions made by individuals who, in our view, set out with a certain course in mind, and they were going to achieve that course, which was the expulsion, regardless of what they did. And so it's not just one thing, and everything that was done, we believe, was done purposefully by the defendants.
Well, I took part of Judge Wilkinson's questions to be if we were to disagree with you as far as qualified immunity is concerned as it relates to damages, wouldn't you still want to pursue your equitable claims?
Your Honor, I see my red light is on. Would you like me to answer that?
Yes, please.
Okay. Yes, we would still, of course, want to pursue the equitable claims. We believe money damages should still be available in this situation.
Well, it's important in qualified immunity to make it clear that under these circumstances, although it may not be clearly established here in the future, it darn well is going to be clearly established that when somebody is faced with expulsion, they should be provided those procedural protections.
And the 2020 Title IX regulations, which went through the Administrative Procedures Act and became law, set forth clearly what those obligations were. And the defendants, the individual defendants, either knew or should have known, they had actual knowledge of what those regulations were. And they violated them, and they violated them purposefully. And at this point in the case, if we're entitled to every plausible inference, I think that there's an entitlement to determine who did what, because many of these actions are well beyond the pale of coincidental or accidental. Many of these actions are very thoughtful. 7 months of knowing that row 1 and 2 withdrew their complaint, changing the school's jurisdiction for this hearing, changing the rules on an interim suspension, knowing that there was a fabricated allegation of owning a gun and threatening people in the fraternity house. All of those things, the investigator and UNC's other individual defendants knew, and they proceeded on this course regardless of that. So when you look at every procedural flaw and you measure it to the 2020 regulations, it's easy to see, I believe, why each of the individuals went out of their way to damage the plaintiff. And in this situation, it can't be that there's a blanket immunity for individuals when there are situations like this where there is a real affirmative intentional wrongdoing.
Well, you would still have your equitable claims and you would still have your Title IX claims in the event that the panel decided not to exercise pendant appellate jurisdiction.
Yes, we
So it's
do.
not as if you're being shut off from your day in court. And I understand you think there are all sorts of irregularities. That is a good reason to have the district court look into them. All right.
And if I may, Your Honor,
Absolutely.
You got up here to argue about Title IX. I hadn't heard you say much about it. It's not your fault. With respect to the Title IX violations, with respect to the Title IX claims, you will have an opportunity to be heard once the final order is issued, right?
yes, that's correct.
All right, and so if we don't exercise pendant appellate jurisdiction, you've not lost anything.
That's correct. In fact, discovery has proceeded on that aspect of the case. The defendants had asked for a stay pending the appeal, stay of discovery on the Title IX issues, and Judge Quattlebaum denied that.
Then do you agree, I assume your position is you don't want us to exercise pendant jurisdiction?
I don't think it's applicable, but I'm still happy to argue why it
No,
is.
yes or no, it's fine.
Then the answer is no.
Okay, thank you.
Thank you, Your Honors. May I be seated?
All right, we thank you, and let's hear from your co-counsel.
Good morning, Your Honors, and may it please the Court. Tara Davis on behalf of the plaintiff appellee Jacob Doe. The Court has already asked Mr. Miltenberg some questions concerning immunity, and I am prepared to ask, or to respond rather, to any additional questions concerning why the entity defendants are not entitled to sovereign immunity and the individual defendants are not entitled to qualified immunity.
Well,
With
what do you do with the precedent that says the University of North Carolina is entitled to sovereign immunity?
This court has stated, and has stated pretty recently, that sovereign immunity is treated as an affirmative defense, and the burden is on the defendant claiming immunity to demonstrate its entitlement to that. Here, despite all the briefing in the district court and at the appellate level, there has been no discussion from the defendants as to how they meet the factors that are required to be demonstrated. And Your Honor, I believe it was Your Honor, Judge Floyd earlier mentioned the Ramdita factors. There is no discussion whatsoever of how the defendants meet those factors here. It is their burden to prove. And
Well, let's say we were to agree with you there and found the district court's ruling on that motion to dismiss acceptable. Would there be any barrier to the UNC entity defendants to file a new motion, particularly raising our prior cases and arguing the Ramdita factors?
I believe the appropriate time to do that would be as part of a summary judgment briefing, because it's also important that we be allowed an opportunity to conduct some discovery related to these issues and
Right, but
whether.
you're not arguing they're stopped from trying again.
I don't believe so. Sovereign immunity is essentially a jurisdictional bar, so to
Right.
the extent they need to raise that at another point, I believe they'd be able to do so. One point I do want to make about their argument with respect to sovereign immunity is they refer to prior cases where the university was found to be an arm of the state, and essentially make the argument that they are an arm of the state as a matter of law. And all of the cases that they cite, I believe, are district court cases, and the most recent of which acknowledged that the university is still required to go through those factors, and it's important to articulate how they meet each of those. And I just wanted to quote from a case from this court, Maryland Stadium Authority versus Ellerby Beckett, Inc., that's 407 F3D 255 from 2005. This court observed that the question of whether an entity is an alter ego of the state is a highly fact-intensive undertaking. Each state university must be evaluated in light of its unique characteristics.
But we're surely not required to go through each of the Ram-Ditta factors if there's a circuit precedent that has applied or assumed sovereign immunity in similar circumstances.
I believe it is still required, and there's a reason that this court has
Well, but
indicated.
not if a precedent, in this case, I guess Huang, has established that sovereign immunity attaches. And I know you can say, oh, well, they just assumed without deciding, but it seemed to me that they went further than that. I'm concerned about the precedent here. And, you know, in the long run, we can't be just concerned about this case. We've got to be concerned about the federal model. And I think the Supreme Court takes the state's ability to assert sovereign immunity very seriously, and not having state institutions just hauled willy-nilly into federal court. And so there's a federalism point that's very significant. And also the Supreme Court cases have indicated that a waiver of sovereign immunity is not to be lightly presumed, because the Supreme Court takes the place of the states in our federal system very seriously. And if a change of venue motion, which seems to me a kind of a defensive mechanism, is held to be a waiver, they wanted to get into the middle district for whatever reason, but to hold that that's a waiver, or just a venue question, I'm afraid that we impair state sovereign immunity for future cases, which seems to me very important not to do.
Well, and I think that's precisely the reason that it is important to look at these factors and why we have this multi-factor framework at play. And recognizing that the purpose of sovereign immunity is to balance situations where state entities are entitled to immunity and where they're not, recognizing that there are situations where individuals should be entitled to seek redress for wrongs. And it could be the case that they're able to meet those factors here. But at this point, at the 12B6 phase, it is their burden to
Right, but
demonstrate.
If we've held before that UNC qualifies, why would we keep going back through that? I mean, unless you present some circumstance that's changed.
So the Huang case was decided 34 years ago, and 24 years after that, in Hutto versus South Carolina Retirement Systems, this court in 2014 revisited the multi-factor framework and stated that the burden is on the defendant to demonstrate this, indicating why it's important to walk through each of those factors. The entity is constantly changing. This is a multi-billion-dollar organization that is constantly evolving. And it's important to look at the entity and whether it meets the factors in terms of its funding sources, its degree of autonomy. That can change, and that's why we have this test in place to examine whether the entity is actually an arm of the state. Is it essentially an extension of the state itself, or is it operating independently to the point that it should not be enjoying sovereign immunity? So again, coming back to the required test, that burden is on the defendants. And at this point, they have not even addressed, let alone walked through each of those factors showing why they are entitled to immunity here. I'd like to talk a bit about qualified immunity, which I know, again, was covered in earlier on, but if your honors have any specific questions about that with respect to the rights that are clearly established. And there was some discussion about the cross-examination issue. I'd like to just note that the Supreme Court in Goldberg versus Kelly stated, in almost every setting where important decisions turn on questions of fact, due process requires an opportunity to confront and cross-examine adverse witnesses. And that's a topic that came up earlier as well in terms of the importance of credibility determinations in these situations where that's the crux of the case, and that's what it comes down to. It's whose account are we going to believe? So to the extent that a party has a meaningful opportunity to be heard, that means having the chance to challenge the evidence presented against you. And the way you do that is through cross-examination and through being able to present evidence that
They're
may-
saying you did have the chance to challenge it, you just didn't have the chance to challenge it in the particular way that you wanted through cross-examination. And that may be the best way to challenge it, but in terms of the qualified immunity doctrine in the future, we have to look not just at this case. And the question we have in all these cases is for something to be clearly established, those words mean something, that the right has to be clearly established. And I think in all of these cases, both your sovereign immunity argument and your qualified immunity argument is a set of sympathetic circumstances that you present to us, but at the same time, our long-range view has to be for the place of the states in our federal system and for the doctrine of qualified immunity and holding fast to the point that for damages to be imposed, they have to really on notice that they're violating clear established law. So this is the conundrum. There are circumstances that are sympathetic, but there are also doctrines that you don't want to impair, or at least I don't want to impair.
So I would say that I don't think we need to impair, even necessarily change the doctrines. I think what we look to here is the well-established rights to notice and an opportunity to be heard. And part of an opportunity to be heard is being able to know the evidence and respond to it. And I would.
We have these precedents here. We have this Huang precedent on the state sovereign immunity point, and then you go over to qualified immunity, and we have the Virginia Tech precedent. And so, it's not a matter of first impression for us. We've got those two precedents, and they have to be dealt with. We have to deal with them.
I see that my time has expired.
No,
May I
go
respond?
ahead.
The last point I want to make is that Matthews versus Eldridge gives us a balancing test for determining what level of process is due. And we have to look to the particular circumstances of any given case in order to figure out what process was due in that particular scenario. Here, given what was at stake, given the fact that the plaintiff was ultimately expelled from every public university in the state of North Carolina, the harm to his reputation, the revocation of his scholarship, all the other damages that will follow him through his future educational and career opportunities, that demanded more than minimum due process. And so I don't think we have to necessarily disrupt precedent to say that due process it depends on the context, and the context here warranted these additional protections that we've discussed.
Well, thank you very much. J.G., do
Thank
you
you.
have any? Judge Floyd, do you have anything? All right.
Thank you.
We thank you, and Ms. Smith, you've reserved some time for rebuttal, and we'd be happy to hear from you.
Thank you, Your Honor. I just have a couple of quick points that I'd like to make on rebuttal. I want to setting aside sovereign immunity and qualified immunity, which again, we've argued that the defendants are entitled to. We also argue that part of the reason that the individual defendants are
Can you
entitled.
speak up, please?
I'm
for me?
sorry, Your Honor. We've also argued that the reason the individual defendants are entitled to qualified immunity is not just because these alleged due process violations were not clearly established, but because they were not due process violations at all. And I want to make a couple of points with respect to cross-examination, and particularly the idea that because these are questions of credibility, Your Honor, that cross-examination was required. Now, I will say that plaintiff has alleged in his complaint that credibility evidence about Row 1's credibility as well as Row 4's credibility was before both of the hearing panels. And so it was not that, they had no opportunity at all to challenge the credibility of these reporting parties. It's just that at least for Row 1, they were not able to cross-examine her to the extent that they wanted to cross-examine her, and that Row 4 did not participate in the hearing, Your Honor. I also want to note quickly that Mr. Miltenberg had referenced the Title IX 2020 regulations. And to reiterate, the Title IX regulations do not set the standard for due process here. So, and I think the panel recognizes that the due process and qualified immunity questions are separate from the Title IX questions. But just to reiterate, even to the extent that Mr. Miltenberg, the plaintiff, alleges that these individual defendants violated the Title IX regulations, which they did not, but to the extent that he alleges that they did, that does not establish a violation of due process. As this court recognized in the Virginia Tech case, the standard for due process in a disciplinary setting is notice of the charges, an evidentiary hearing, and an opportunity to present a defense, Your Honors. Finally, just quickly with respect to the Title IX question and this court's pendant appellate jurisdiction. One of the reasons we believe that question is properly before this court, Your Honor, is that the defendant's Title IX claim rises and falls on whether or not there were procedural irregularities and due process violations here, Your Honor. So if this court concludes that there was no due process violation, the Title IX claim must fail. And because of that Title IX claim is inextricably intertwined with the qualified immunity claim.
In a number of cases, the precedents are on your side, but I wonder on the pendant appellate jurisdiction, our cases have been very skeptical about the exercise of pendant appellate jurisdiction. It's not flatly forbidden, but the exercise of pendant appellate jurisdiction is not favored.
So I grant that, Your Honor. I would point this court to the 2024 decision of the court in the Elegant Massage case, where the court did recognize that pendant appellate jurisdiction was warranted. And that was a case where there were two distinct issues that were brought before the court. There was an interlocutory appeal of a denial of a motion for, it was a denial or a grant
Yes,
of the...
in the Title IX cases, there are a lot of different regulatory requirements that aren't necessarily present in the constitutional due process thing. I mean, Title IX claims and constitutional due process claims, to a certain extent, they run on separate tracks. And I can't see it getting here because to the extent that any regulations are pertinent to the constitutional claims, they're the North Carolina systems regulations and what have you. But the the factual basis of the two, of the Title IX and the due process claims may be very similar, but the legal analysis required for each of those strikes me as different.
Well, Your Honor, I think that the way that they intersect here, and I see my time is up if I may respond to Your
ahead.
Honor's question. The way that they intersect here is that in order to allege a Title IX claim, the defendant must prove not only procedural irregularities, but that there were particular circumstances that show an inference of gender bias. And the way that plaintiff has attempted to do that is to point to those procedural irregularities. And so essentially the way that plaintiff is attempting to show an inference of gender bias is by saying that there were due process violations. And so that is where these claims intersect, Your Honor,
Well,
and that's how.
That's creative. I have to,
Thank you, Your Honor.
I have to say, Judge Agee, do you have any? No. Okay. Thank you very much.
Thank you, Your Honor.
I'd like
I appreciate this
to
court's time.
thank counsel on both sides of this case for what was a very ably and conscientiously presentation and at an oral argument. And we'll come down and say hi to you, and then we'll move into our. Oh, okay. Judge Agee and I will come down and please come up and say hello to our friend and colleague, Judge Floyd. Mr. Shafley?
Thank you, Your Honors. May it please the court. My name is Andrew Schlafly. I'm here representing Dr. Roland Shalafo, who's in the courtroom today with us. He's the plaintiff appellant, and he's a neurosurgeon and interventional pain surgeon who operates on patients who are in pain, such as inserting a morphine pump into their back. And his operations are somewhat unique compared to other types of surgeries in that the patient is awake during the procedure. So that takes a little getting used to. The medical aspects of this case are not really relevant to this appeal. I just give that to you by way of background. He practices in good standing with his medical board. He was in good standing with the West Virginia Osteopathic Board at all relevant times during this, the facts of this case. That's just by way of background. Defendants have a bit of a monopoly in West Virginia over this type of procedure, and they took actions to exclude Chalifot from the market because he was an independent physician in that market. So hospitals, as the allegations in the amended complaint set forth, hospitals make more money when their employees are doing these surgeries. And Chalifot was independent, so the monopoly that defendants have in West Virginia took action to exclude him. And as part of that, they did a peer review, which was really a sham peer review, and they reported it to the National Practitioner Data Bank.
Well, Counsel, so I'm sure I understand where you're going here. My concept of this case was it basically related to whether or not the settlement agreement was valid and whether your client's counsel had the authority to act for that. That is the issue here, isn't it?
Yes, Judge Agee, and also the issue of whether a settlement can include removing an entry in the data bank. So the judge below, in approving the settlement, there wasn't a settlement, in approving the terms that defendants wanted, he said, I cannot give Dr. Chalifot the relief he wants of being removed from the data bank because it would be illegal for me to do so. So you're exactly right, Judge Agee. The primary issue on this appeal is whether plaintiffs settled, agreed to the settlement and the procedure by which that occurred. But the data bank issue backs into it because the district court judge was mistaken in his belief that he could not approve a settlement that included removal from the data bank, and therefore the district court judge concluded that that cannot be a term of settlement that plaintiff would want or could insist upon because it would be illegal.
I thought the district court held that, based on the facts as it understood them, that all of the non-economic issues had been settled, and if that were the case, whether or not he made an error as to whether the report could be voided really wouldn't make any difference.
That was part of the reasoning, Your Honor, but there was no evidentiary hearing below. And so plaintiff contests that the non-economic terms were settled, and really non-economic did not encompass the data bank issue. When the term non-economic was used below, they're talking about enforcement of the settlement, jurisdiction, terms of payment, releases, but the data bank was such a big issue and always has been throughout this case. It's in the
The court
complaint.
said that, that the only thing left was the amount of cash that was going to get paid. Are you saying that that was, there's no evidence in the record to support that, or?
That's right, Your Honor. There's no evidence in the record to
Which is a pretty high
support that.
burden. This is a very high burden to say there's nothing in the record.
Well, Your Honor, there just is nothing in the record. The judge did not hold an evidentiary hearing. So I assume counsel for defendants, appellees, will stand up here and say, yeah, all non-economic terms were settled. There's nothing in the record to support that. There was no hearing
I
below.
don't see how it's possible, though, in light of the statute that Congress has passed, the Healthcare Improvement Act, for us to sort of open the door and say that you can, that any physician can settle his or her way out of the adverse report, that if that's something that can be negotiated away in the course of a settlement proceeding, you've kind of landed a heavy blow to the statute that Congress has passed, which was to have a national data bank that hospitals could refer to so that they wouldn't be awarding staff privileges to someone who's going to do patients substantial harm. And so I did the whole, and I think the defendants, the district court found, and the defendants can say that they made a point of the fact that they didn't have any legal authority to simply pull the report that they were required under the law to make. And they would have gotten, had they tried to do so, I think they would have been in a host of legal, they would have brought on themselves a host of legal problems.
Your Honor, that's an excellent point. But what we're talking about here would be a court-approved settlement. We're not talking about a side deal that the court would not have any involvement in. And if a plaintiff can sue for certain relief, and Plaintiff Shalafo did sue for this relief, if you can sue for it, you can settle for it with court approval. The notion that a federal court is without power
You didn't fare too badly in this settlement. You got $300,000 out of it.
well,
It's not, it's not bad for, not a bad day's work. And as to the anti-disparagement statement, the defendants actually agreed with your language. And then the only remaining issue is the NPDB report, which the defendants, as far as I can tell, had no authority just to sit there and negotiate that away and to rescind it.
and Your Honor, I think you're right on their own, the hospital has no authority. But we're talking about a court-approved settlement. And if someone can sue for something, they can settle for something with court approval. The $300,000, you're right, Judge Wilkinson, is a significant amount of money. And it suggests the hospital agreed this was not entirely proper. I mean, they didn't, well, I can say that in a settlement, of course, but they agreed there's something wrong here. Now, if there's something wrong
Well,
here.
the district court, I think, made the point that the act itself, that you want the report to be rescinded, the act itself has a process by which you can contest the findings. And I think it was the district court, but it didn't seem to me that this was in dispute, that the process that the act lays forth for you to contest adverse findings was something that you declined to avail yourself of.
Your Honor.
So you're using the settlement process to circumvent the process that's set forth in the act, in a way.
Judge Wilkinson, with all due respect, that's not really correct. The process is to sue. There's no process with the data bank. The district judge mentioned that Plaintiff Shalafo inserted a rebuttal into the data bank, but that doesn't do it. The stigma is still there. The process is to sue, which is what Plaintiff Shalafo did. Now, if the position of this court is going to be that
Well, okay,
you can't
but-
settle
all right,
your lawsuit,
I'm
then we
not-
want to sue.
all right, excuse me.
Yeah.
I'm not saying that, you're saying the process is to sue. But there, even assuming that I would agree with you, there you run into another problem, which is the fact that the standard of review here is abuse of discretion and clear error. And it's not as if the district court just whisked his way through it. The district court reviewed the motions carefully, reviewed the correspondence between the parties. He heard from your client on the NPD report. He heard from the parties at a court hearing. He didn't just say, oh, the case is settled. He went through a lot of different steps. And when a district court does that, and the standard of review on appeal is one of deference, whether it be abuse of discretion or clear error, and we recognize that district courts have a a better view often of the settlement process than we do on appeal. They're simply closer to it. And so, you know, on the one hand, it seems to me you're running into the process, you're circumventing the process the act sets forth, and then you said to, oh, well, the process is to sue, which you did, and the district court made findings. The district court said that the settlement was reached, and we have to review that under a deferential standard. So I think you're running into walls, whichever path you wish to take.
Your Honor, the standard on reviewing whether the settlement existed, whether it occurred, is not clear error, it's de novo. Whether a party entered into a settlement. The terms of the settlement would be clear error, but whether he
I
entered
thought the
into the
issue was
settlement.
whether or not the appellant's counsel had the authority to enter into the settlement agreement. It seems like to me that's, I mean, the district court found that, West Virginia law seems to support it. Tell us why that was error.
The error is that under Hensley, Oville, clear precedence of this court, the district court has to conduct an evidentiary hearing.
All right, well, let's assume he did an evidentiary hearing. What I'm interested in is, why do you say that counsel for the appellant did not have the authority to enter into this agreement?
He did not have the authority because he had been instructed many times by Dr. Shalafo that removal of the data bank is essential to this lawsuit. This is a main reason why I'm suing. And they
Well,
went
there
to
was-
mediation, the mediation was unsuccessful.
Okay, there was a fair amount of in-camera information the court reviewed, and I'm understanding that none of that related to an instruction from the appellant to counsel. And regardless of what our Fourth Circuit cases may say in the abstract, we're looking to what West Virginia law says about an attorney's apparent authority. And there is a presumption in West Virginia that has to be rebutted by an appellant that the counsel did not have the authority to settle. That's stronger than the common law presumption. It's pretty strong in West Virginia. And I'm not seeing how you've done that.
The plaintiff is the captain of the ship. He decides whether there's going to be a settlement. I don't believe under West Virginia or any other jurisdiction, and I don't believe the district judge cited anything in West Virginia that says an attorney can come back one day, it was an email, after mediation was unsuccessful, and send an email a month later, hey, I settled the case. And Dr. Shalafo's like, what? Immediately said to the attorney, no, you didn't. There has to be a removal of the data bank entry. And they go to the judge, district judge, and he's like, well, I can't do that. That's an illegal demand that you're making for settlement. It's not illegal. That's the purpose of the suit. And if there can't be a settlement with that included, then let the lawsuit proceed to judgment. He
All right,
needs that removed.
At this point, I'm going to ask my co-panelists if they have any further questions. Judge Agee, Judge Floyd. We don't have any further questions.
Okay, I reserve some time for rebuttal.
Thank
Thank
you. Mr. Giotto?
Yes, thank you, Your Honor. Good morning, gentlemen, and may it please the court. I'm Gene Giotto on behalf of Wetzel Hospital and the other defendants. Attorney Nathan Hammonds is in the courtroom.
Can you
with-
put the microphone very close to you and
How's
speak
that?
up?
How's that?
That's great.
Good. Respectfully, Your Honors, Judge Bailey, in our view, did not commit an error of law, nor did he abuse his discretion in determining that original counsel for Dr. Shalafote had apparent and, quite frankly, actual authority to enter into a settlement. As the record reflects, and as has been documented in the briefs, original counsel was involved in the case from the inception of the complaint in December of 2022. There was motion practice that went on in June of 2023. Judge Bailey denied our motion to dismiss. In August in August of 2023, original plaintiff's counsel and I discussed the possibility of exploring settlement. He filed a motion to stay discovery so the parties could engage in early mediation. Judge Bailey stayed the proceeding, and a mediation was held in front of mediator Stephen Delizio in early October of 2023. Now, before that, counsel and I had interaction about settling. And in March of 23, he expressed Dr. Shalafote's desire that a first starter in settlement negotiations would be to be withdrawing the National Practitioner Data Bank that was filed by the hospital pursuant to our statutory obligation. The communication back, and the record reflects that that was a non-starter, and the communication was, as Judge Agee, I believe, identified, we did not have the right to withdraw something pursuant to the guidelines. The statute indicates that there are 3 factors by which a health system, a hospital, can withdraw a national data bank reporting. The first is the report was submitted in error. This one was not. The second is the action was not originally reportable because it did not meet the National Practitioner Data Bank reporting requirements. This one complied with those requirements. And the last was the action was overturned on appeal. This one was not.
Well, counsel, let me ask you, if the district court found, and there was evidence in the record to support it, that there was a settlement of all disputes between the parties except for the amount of cash, would it make any difference whether or not the NPDB report was to be discussed? I mean, if you settled everything but the cash, what difference does it make?
I don't know that it does, Your Honor, quite frankly. And if you think about it, we went through the mediation request, we went through the mediation, and there wasn't a word about the National Practitioner Data Bank report. And the judge highlights that in his report. There was not a discussion from counsel at the argument in front of Judge Bailey on our motion to enforce in early December of 2023 by original counsel about the National Data Bank reporting. To the contrary, counsel indicated that that issue was put to rest back in March, early on in the negotiation, before we even submitted the draft settlement agreements of the non-economic terms. As the court indicated during the appellant's argument or discussion, when we got to the mediation in October, all non-economic issues were removed, were done. There was a day-long mediation. There was not a word about the National Practitioner Data Bank report, not one word. We don't resolve the economic issues at the mediation. There continues to be dialogue between counsel and I about the settlement, about the economics. At no time was there a manifestation from Dr. Shalafote or his prior counsel that it was not reasonable for us to assume that counsel had apparent and actual authority to settle the case. That was the determination made by Judge Bailey at the argument on the motion to enforce in early December. With respect to the Hensley contention that it was not a plenary hearing, we respectfully disagree. It was a robust, thoughtful hearing that was scheduled. The record was transcribed. A thoughtful argument was made by both sides. Much was conceded by plaintiff's counsel, Attorney Kaminsky, at the argument. Dr. Shalafote was given at least 2 opportunities to be heard separate and apart from his counsel. Judge Bailey concluded, and rightly so, that the record was clear that there was a settlement and counsel had the authority to bind his client to the settlement. After that, original counsel withdrew his appearance. New counsel entered their appearance. They filed a motion for rehearing. Judge Bailey considered it and wrote a thoughtful opinion, again indicating that the record evidence in this case established that an effected settlement was established. The record's clear, Your Honor. There was not one word about the National Practitioner Data Bank after March of 2023, and for counsel to suggest that Judge Bailey should somehow add to the settlement that which was not negotiated, was not a condition precedent. It's just mistaken. There's a representation in the case that for some reason by our filing the motion to enforce, that somehow should negate the settlement. Quite frankly, that's not consistent with the local rule, Rule 26. We have an obligation to file the motion to enforce. There's not, the rule in the case law dissuades trying to file something under seal. The Tilley case addresses it clearly. Quite frankly, Your Honor, there's nothing further I think I can add. I think the record's clear in this case. Judge Bailey's decisions are clear. The transcript is clear. And at all times throughout the duration of this case, it is clear that there was no manifestation that Dr. Chalafote ever exercised anything that would give the defendants any indication that his counsel did not have actual or apparent authority to settle the case. It was settled. The last thing with respect to this reputational damage on the National Practitioner Data Bank, this isn't the first time there's reports of Dr. Chalafote
Even
in the
if
data
there
bank.
had been a word about the, you say there was not one word about the National Physician Database Report. And I see no reason to disbelieve that. But above and beyond that, if we tried to put our imprimatur either directly or indirectly on settlement agreements that rescinded adverse reports to the National Data Bank, I think we would be dealing a serious blow to the whole purposes of the statute, which was to call forth and notify hospitals so that they don't give staff privileges to individuals who have made, in the judgment of their peers and fellow physicians, serious medical mistakes that cost lives. And I understand every time staff privileges are suspended for a physician, there is invariably a claim that this is anti-competitive conduct and that they didn't want, that those who are members of a particular specialty did not want somebody else coming in. That claim is always made. And Congress in this statute, it seems to me, tried to balance those factors, tried to give the physician who is on the adverse end of the findings a path by which to challenge those, and at the same time alert hospitals in other areas about individuals' deficiencies. And if we were to put an imprimatur on settlement agreements that let this be bargained away, we'd be upsetting the balance that I think Congress tried to strike between these competing interests. That's the danger.
Thank you, Your Honor. I appreciate your point. I agree completely. Just to conclude, unless there's any other questions from the panel, the record is clear. We certainly believe that Judge Bailey's decision is sound based upon the evidentiary record, and he certainly did not abuse his discretion. I'll take any questions should you have any.
Thank you.
Thank you, Your Honor.
Did you have any questions?
Your Honor, first to address Judge Wilkinson's point, which is an excellent one. Hospitals don't always act properly. And maybe most of the time they do, but in this instance they did. And they've offered to pay $300,000 for their wrongdoing. And a judge can look at that, look at the magnitude of that payment, look at the facts, and since we've opened the door here to what were the facts, I just want to point out, the allegation was that the patient, while awake during one of these procedures, said stop. And that plaintiff Shalafo did not heed that. Well, he did heed it, but the reason the patient said stop was not because of the injection in his spine, was because he was having a Charlie horse. That's what all this stems from. The real motivation was economic, and hospitals do act economically, and they do abuse their power sometimes under this statute. And when they do, it's for a federal judge to look at it, look at the facts, look at the amount of money they're offering to pay, and say the reputation should be cleaned up too. And the hospital wants an anti-disparagement clause by plaintiff Shalafo, yet they want the disparagement of plaintiff Shalafo to continue in the data bank. And the citations by opposing counsel, I think he said it was in the statute, he's citing to a guidebook by the federal agency about voiding a report. That's merely a guidebook. It's not even a regulation. It's an internal guidebook. They put it on the internet. But that's what he wants a federal court to defer to, an agency guidebook. Well, we're long past that now. With the Loper-Bright Enterprises decision by the Supreme Court, federal courts do not defer to agency guidebooks on issues of law. And a federal court, this is the relief that plaintiff Shalafo seeks. He has that right to seek it in court, and it's been taken away from him by this crazy procedure that surprised all of us. My opposing counsel stood up here and cited a number of claims about whether the data bank was part of negotiations. None of that's in the record. None of that. He's saying, I wasn't told about this after a certain date, it wasn't raised in negotiations. None of that's in the record. No way to cross-examine him, no way to rebut it, except to tell you, plaintiff Shalafo insisted on removal of that data bank at every step of this procedure, including mediation. And he was at the hearing that the judge had, it was just a motion hearing. He could have been called to the stand. The judge could have asked him questions, which is required under Hensley. Hensley is very clear. If we're talking about the existence of a settlement agreement, not the terms, but whether a settlement was entered into, there has to be a plenary evidentiary hearing. There's no doubt that that's the controlling precedent. That's not the only case either. Alville v. Grafton Holmes said the same thing.
Are you arguing that at the hearing Judge Bailey conducted that it was prohibited to introduce evidence?
No, he should have allowed evidence added. He did not.
Well, what evidence was proffered but not allowed?
Plaintiff Shalafo showed up at the hearing. He was there to testify. He tried to talk. The judge rendered his decision before Plaintiff Shalafo could say a word. And Plaintiff Shalafo would have explained the whole purpose of this lawsuit was to obtain removal of the data bank. Every step of the way, it was a point of negotiation. And if they don't want to settle, if they want to do that, fine. We'll go to trial. We'll let a jury hear that the whole case stems from a Charlie horse that the patient had briefly during surgery. That's what their case rests on. They know what they did was wrong. They've offered to pay $300,000. But the stigma of the data bank continues, and people are misled by that. The data bank doesn't want people dumping in false or misleading allegations into the data bank. It's misleading. The data bank entry doesn't say this all stems from somebody's Charlie horse during an operation. And so respectfully, Hensley and many other decisions are crystal clear that a plaintiff is the captain of his ship. An attorney does not settle a case for a plaintiff without that plaintiff's explicit approval that we're going to do a settlement. And in the mediation, Plaintiff Shalafo was a good sport. He was there the full day till about, it was after 4, and Plaintiff Shalafo finally said, okay, this isn't getting the settlement that I'm looking for here, I'm leaving. The mediator filed a report about 10 days later. Mediation was unsuccessful. The case should proceed. The district court judge then entered an order. The case is going to proceed. We're going to go to discovery. We're going to do a schedule and everything. And then a month later, Plaintiff Shalafo's attorney sends him an email. I settled the case. I settled the case. That's not due process. That's not the way the procedure works under the clear precedents of this court. The data bank, it has its purpose, but for the guidebook to say that you can't void a report unless it's overturned in appeal, of course, that implies settlement too, that's court approved, that implies court settlement, but for them, someone then say because it's the wording in the guidebook prevents a federal judge from approving a settlement that cleans up the data bank of something that's misleading, I mean, that's just legal error below.
Thank you, sir.
Thank you, Your Honor.
You okay to go with the next case? You okay to go with the next case? We'll come down and greet counsel and proceed into our final case, and I'll ask you to come up and greet Judge Floyd personally. at any time.
If he's entitled to do it, yes.
He's entitled to do that.
Your Honor, I'm not sure, what I said, I'm not sure that I was clear. He can do it if he is in fact entitled to it.
Yeah,
Yes.
but in this case, I think Judge Hudson made a point that there were still ongoing proceedings with respect to Mr. Brown. I guess they were 2255 proceedings or retroactivity questions, and so why wouldn't the privilege attach to Mr. Brown if there were ongoing proceedings that posed a potential of prejudice if he were to respond to the questions?
Yes, sir. Because after the direct appeal is over, and you draw that bright line, you have it all the way through your sentencing and through direct appeal and cert. No question about that. The question after that is, how does that continue and under what circumstances? So that has not been addressed, as I said, by either the Supreme Court or this Court of Appeals, or quite frankly, really any other Court of Appeals. There are two district court cases that address it, one from the District of Arizona, Milkey, and the other from the Eastern District of New York, Pipitone, and they say that once the direct appeal and cert are over, that the determination of whether a witness is entitled to invoke the Fifth Amendment privilege is dependent upon whether or not there is a real, a substantial and real hazard of incrimination. So it is a fact-specific examination as to that defendant and the evidence which he is being asked to
All right,
give.
well, just listening to what you just said, if it is a fact-specific determination which hinges on the particular circumstances, in other words, how material is Mr. Brown's testimony and how great is the prejudice likely to be and everything, is this not a matter that we would defer to the district court on?
No, sir. The right to take the privilege is a matter of fact and law, mixed question of fact and law, that this court, according to the Lara case, that this court decides on de novo review.
Well,
So-
let me ask you this. I'm a little confused about what Mr. Oliver sought to show by authenticating the letters. And I don't understand how it impacts the outcome of his case. What was he trying to show?
Yes, Judge Floyd. He was trying to show that, in fact, so Mr. Brown's statement to the police was introduced at trial. And that statement had implicated Mr. Oliver as having provided him with the gun. Mr. Oliver was trying to show that that in fact that was not true, that testimony was false. It wasn't in order to establish innocence. It was in order to establish whether the guidelines should apply. He would have been presumably guilty regardless of whether he'd supplied him with the gun under the government's evidence. So what he was trying to do is that should not be assessed against me as part of my sentencing. Whether it's part of the guidelines, he received because the 924Cs had been thrown out, he was assessed 7 levels for the gun. But in addition to that, the upward variance, it was relevant to that as well. So he was trying to attack the basis of the sentencing.
So how do those letters show that?
Well, the letters showed that he basically said and quite frankly, I can't read them all, just the handwriting, but he was trying to show through the letters that what he was saying to Oliver was, I didn't tell the police what they say I told you. I didn't tell the police what they say I said.
you mentioned in the course of your comments the upward variance here, and you made a lot of different claims. But how can we criticize the district court for the upward variance if it is true, as the government contends, that he had 27 prior convictions and 7 prior felonies, and that he had been in confinement for 8 years, and that had no effect, apparently, on his desire to recruit somebody for an armed robbery of a small business. I mean, you made a lot of claims here, but one, and I think that's fine, but I don't understand how in the world somebody with these kinds of convictions on his record, 7 felonies, 27 prior convictions, 8 years of confinement, no effect. And how can we possibly overturn Judge Hudson on something like that?
Your Honor, I would address it only briefly to say that many of those were part of his juvenile record, and that indeed in the most recent amendment to the federal guidelines of 5H1.1, the federal guidelines now recognize the fact that we have to take into account when we analyze a juvenile record what the juvenile circumstances were. The probation report in this case from Mr. Oliver is unlike any probation report I think I've seen in the past, which is that it is detailed as to the problems of his upbringing, of his failure, his parents' failures, the system's failures to give him the care that was needed. So the juvenile record has to be taken not with a grain of salt, but it has to be taken in context.
Well, what evidence do we have that the district judge didn't take everything into account? I mean, there's no limitation placed on the information that can come before a district court at sentencing, and it was certainly up to the district court to take into account that some, I don't know how many, certainly not all, of the prior convictions were juvenile. That's not always to excuse them, but given the sheer number of convictions, they can't all be juvenile convictions.
They are, Judge, and many of them are driving on a suspended license convictions. Now, I understand that that's a violation of the law, but they're also not armed robberies, and they're not they're not violent crimes, they're not serious crimes. They are driving a suspended license. And people get in a cycle where they can't, we know this is true, you can't pay your fines, your license is suspended, and you get more and more driving on suspendeds. But that isn't the kind of thing that justifies, I would respectfully suggest, an upward variance. I would like, though, to turn, because more importantly, I think, in this case, is the consecutive sentences, because without the consecutive sentences...
Before you get into that,
Yes, sir.
why don't we go back to what I thought would be your threshold point that you have to get through? And as I understand it, we're holding an appeal of Mr. Brown's in abeyance now. But I would think you would need to explain to us why Mr. Brown is not at risk for Fifth Amendment purposes.
Yes, Your Honor. And it's because he has affirmatively accepted responsibility in court and in his letters to the judge and in his letters to the victims for having the gun, for shooting them, for the armed robbery. He has personally done that, and in his statements to the court, and as I said, in his letters, and he's done it through his counsel. He has done it in sentencing allocutions, sentencing memorandum by his lawyers, and so there's nothing that he could say that would change what already exists in the record. What exists in the record is, I did the robbery, I am responsible for it, nobody else is responsible for what I did, I am, I took the gun in there, I shot at the cashiers, I shot at Mr. Edmonds, shot him 4 times, I did all of that, it's mine. So
If Brown were to have testified and the government then elicits information as it said it would on cross-examination that he has repudiated earlier statements upon which maybe his prior conviction and sentence were based, you think that offers no jeopardy to him at all?
Not given everything that he has said and done. I do not. You know, I mean, there's a certain point at which piling more on just doesn't matter. And he, of course, has received upward variance and the maximum sentence on both counts consecutively. So what is he going to say now that is going to not simply just be irrelevant, piling on to what he's already done and what the judge has already found? The judge can only do but so much to him, and he's already done it. So no, I don't think that there can be any effect. He's taken it all on himself. There's nothing he can say now that would change the equation. He doesn't have a right to commit perjury, and so, you know, that's not an issue. He can't get acceptance of responsibility because he went to trial. So there is no, and he's admitted responsibility. So there is simply no, there's nothing there can hurt him any more than that. And in fact, the government hasn't really been able to identify anything. Now, one of the things about the Milky case and the Pipitone case is that what they talk about is it has to be and also, although I don't usually cite state Supreme Court cases in this court, but I did in this instance because it was so directly on point, and that is the case out of the Kansas Supreme Court. And what they said was it has to be direct and specific. And the government has never been able to identify anything direct and specific. At Joint Appendix, page 804, the government gave its reasons of why he might be harmed. He might say he was more involved and Oliver less. It's inconceivable. He is on the video going into the store. It's not going to say I was more involved and Oliver less. He said, he might say Oliver didn't give him the gun. It would put more onus on him. He said it's no more onus than taking the gun, well, whoever gave it to him, and walking in there and shooting at the cashiers and shooting Mr. Edmonds 4 times. They said if his statements made him an organizer or leader, obstruction based on the letters. He didn't submit the letters to the court. I don't understand where their idea of obstruction comes from. So he wrote a letter to his co-defendant who was also incarcerated. Your Honor, I see my seconds are dwindling.
Isn't it a finding of fact with respect to the obstruction enhancement that he prevailed upon Love to sign affidavits that whose falsity he knew?
He didn't know the falsity, Judge. That's the whole point. How could he know it? She thought that Roderick Young, D.A. Roderick Young, she thought he was
What do we do with the finding of fact on the part of the district judge with respect to the obstruction enhancement, where he says, I think there was a clear attempt here, both in the affidavit he instructed M.S. Love to sign and the attempted recruitment of Brittany to suborn perjury.
First of all,
two different instances.
and first of all, it's clearly wrong. She didn't know that it was false. How could he know that it was false? He wrote it for her. She had told him this is the federal agents pressured me. She didn't realize it was really the state agents that did it, and when she put Roderick Young in, she didn't realize that he was, in fact, an AUSA. So she messed it up. He had no way to know that that was false. And she, prior to the hearing, reaffirmed to me, and that is in the record, she reaffirmed to me that in fact, she was wrong about the identity and he didn't know it. So the judge is wrong about that. As to the other instance, Your Honor,
No, you say not just wrong, but clearly erroneous.
clearly erroneous. And there's no evidence to
Not
support it.
only with respect to Love, but with respect to Brittany too?
Well, no.
Did he miss them both?
No, that's not, I'll tell you why, Miss Brittany, it's not that. It had, to be obstruction, it has to be a substantial step. Giving the name Brittany without a last name, without any contact information, no phone number, no email, no address, just Brittany, find her.
All right.
That is not a substantial step to constitute obstruction.
Judge Floyd, do you have any? Judge Agee?
Thank you, Your Honor.
Thank you, Mr. Zirkin. You have some rebuttal time. Mr. Honold, pleasure to hear from you.
Thank you, Your Honor. Good morning, and may it please the court. Daniel Honold for the United States. This court should affirm because the district court did not abuse its discretion either in declining to force Mr. Brown to testify at Mr. Oliver's resentencing hearing or abuse its discretion in sentencing Mr. Oliver to the statutory maximum consecutive sentence of 480 months in this 2255 resentencing. I'll begin where my friend did with the Fifth Amendment issues. I heard my friend to dispute what the applicable standard of review is. Our fundamental submission is that in a situation in which a district court is both balancing competing interests.
Can you speak up a little for me?
Yes, Your Honor. Is that better?
Yeah, it's my hearing, it's not your problem.
Yes, Your Honor. In a situation in which a district court is being tasked with balancing two competing constitutional prerogatives, one on the part of the witness and one on the part of the defendant, and is further being instructed to engage in a particularized fact-bound determination about the credibility of the witness's potential risk of incrimination from being forced to give the testimony. That's a very classic type of situation in which, similar to balancing the 3553A factors, doing 403 balancing, these things are typically committed to the discretion of the district court, and we submit that that is the standard that should apply here.
There can be two different standards for two different things, I think, because there's an initial question of whether or not the ability to exercise the right exists, and that strikes me as probably de novo review. But then there's a subsidiary question on, well, once the district court made that determination, how did it go about implementing it? And I think that's where you get to the abuse of discretion part.
I agree completely, Your Honor. And of course, as we point out in the Flint water case from the Sixth Circuit, these questions will ultimately reduce to the same question where if a district judge commits an error of law, that's going to be an abuse of discretion. So it's not inconsistent to have those two dynamics at play in the same situation. And I'll just point out in the Laura case that my friend relies on, that was a situation in which the district court was assessing whether or not the defendant himself was going to have a privilege that was recognized. And that's a very different procedural case from what we have here, where you've got a defendant attempting to compel a witness to lose his Fifth Amendment rights. And so you don't have the balancing at play in the Laura case. So the de novo review there is simply not applicable.
Well, Mr. Zirkin says, as regards to Mr. Brown, that he was at no risk, and therefore the privilege shouldn't apply. So why don't you tell us why you think he's wrong about that?
Yes, Your Honor. As the district court found at JA 811, in the context of this case, with his deep familiarity with the facts and circumstances, both of the previous trial record and what was at issue in the sentencing hearing, the district court did not clearly err in finding that there was a substantial risk of prejudice to Mr. Brown from being forced to testify about these letters. There are two, I think, possible dynamics at play here. One is the potential risk of sentencing exposure. As we've discussed today, Mr. Brown's case is currently on direct appeal from his own de novo resentencing in a 2255. He's essentially in the exact same procedural posture as Mr. Oliver is right now, except that his case is being held in abeyance. If this court were to grant Mr. Brown relief and resentence him after a situation in which he's been compelled to testify about these letters and his involvement in this robbery scheme, that could very well prejudice his ability to seek a lower sentence. The government would be able to present that new information to the court, and it could further support the government's re-request should relief be granted for a top of the, not atop the guidelines, but an upward variant sentence to the statutory maximum, which is what we received in the last instance. There's also the possibility that it could open him up to additional charges. This isn't really fleshed out as much in the hearing, but in the second letter that's purportedly from Mr. Brown to Mr. Oliver, one of the reasons why Mr. Brown is purportedly attempting to convince Mr. Oliver that he didn't talk to the police is on the basis of, well, if I had talked to the police, those other charges against you wouldn't have been null prost, but they were null prost. And you can see in the PSR that there are a series of null prost robbery and burglary offenses from around the same time. So there's, even putting aside the notion, which we assert in our brief, that sentencing exposure on its own is enough to allow someone to invoke the Fifth Amendment right, he's also got the potential for other charges, which would, I think, unquestionably be sufficient. As to the particularity of that, I think we have to be very careful when we're talking about the invocation of a Fifth Amendment privilege. To require more granularity than that was posed here would sort of defeat the purpose of having the privilege in the first place. If someone has to get up there and say, I don't want to invoke the privilege because I'm afraid of being charged with X, Y, or Z, that kind of undoes the whole purpose of why we have the privilege in the first place. So we think that the level of specificity and granularity was adequate here without exposing Mr. Brown to the risks that are inherent in being compelled to testify. Taking a step back, I do want to make clear for the court what the government's position is on when the right attaches and reattaches at certain procedural points. I heard my friend say that, failing to draw a bright line rule after, a petition for certiorari is denied, doing anything other than having that be the rule would cause confusion. I don't think that's quite right, and I don't think it tracks with principles of fundamental fairness to people who are attempting to invoke these rights. Our submission is that if someone's conviction or sentence, the finality of that is disturbed to a sufficient extent that it is no longer fully final, as in the case of the grant of a 2255 motion and a resentencing thereon, then the privilege is going to reattach at that point through the lifetime of that resentencing.
Can I return
appeal.
for a minute to the issue that Mr. Zirkin has highlighted on the Fifth Amendment privilege versus the Sixth Amendment right to compulsory process? I'm always looking for ways to keep things a bit narrow. And if we affirm here, we're saying nothing more than there was no abuse of discretion considering the particular circumstances of the case, among them the materiality of what Mr. Brown might have to offer, the degree of prejudice that Mr. Brown might suffer. In other words, it's a very particular decision. But if we reverse and say that the Sixth Amendment right overrides the Fifth Amendment process, that's a much broader ruling, and it would be an incentive in every case to hold that the Sixth Amendment right overrode the Fifth Amendment privilege, even where the Fifth Amendment, the assertion of the privilege may have had compelling reasons. So the affirmance here seems to me to be fact-specific to this particular case, and the reversal seems to me to send a broad signal that in a clash between the Fifth and Sixth Amendment values, that the Sixth Amendment presumptively controls. And I think we could do some real damage to the Fifth Amendment in that kind of situation, because there may be compelling reasons that people want to not to incriminate themselves. And I'm nervous about sending that big a signal.
I share the court's reservations on that ground. A reversal on that ground would be disruptive to, I think, a long line of settled case law in which the proper invocation of the Fifth Amendment privilege is going to override the Sixth Amendment right to due process. And you'd be doing it in a situation in which a defendant is attempting to compel the testimony of someone to be a witness for them at their resentencing. It would be an odd posture in which to issue a reversal on those grounds. Especially in a situation whereas here, we've got strong arguments that any error, either legal error or in the particularity analysis, would be harmless on this record. We've got, I think the court needs to really look at two sides of the same coin. One being is, what is the weight, the potential weight that these letters could have had they been admitted and the court saw them for what they were, against the second side of the coin, which is all of the other completely independent evidence that the court had before it of Mr. Oliver's guilt, of Mr. Oliver's responsibility for these sentencing enhancements, and the 3553A factors. And I think when the court looks at it through that lens, it's pretty clear that the letters themselves carry very little weight. They don't, they don't claim to establish his factual innocence in any sort of way. They're just sort of protestations that Mr. Brown said he never spoke to the police at a certain really unknown time in the past. The most it could do is possibly cause the district court to question the veracity of Special Agent Umflitz's sworn testimony at trial that Mr. Brown did in fact speak to him about this case. And there's no evidence on this record that the court would have been that persuaded. And even if it had been and completely disregarded Special Agent Umflitz's recitation of Mr. Brown's confession, there was a tremendous amount of independent evidence establishing that Mr. Oliver was the mastermind. Mr. Oliver provided the gun, both through witness testimony and DNA, and post hoc efforts to cover up by, for example, calling his pastor and asking him to hide the gun and get a message to his brother to do that. So there's ample grounds to affirm, both on the merits and on even on assumed harmlessness error analysis. I'm happy to turn, Your Honors, to the sentencing questions. I think the only areas that my friend touched on were the obstruction enhancement and the upward variance and consecutive sentences, which really go hand in glove. So starting with the obstruction enhancement, as the district court very clearly found, and it is subject, as Your Honor mentioned, to clear error analysis.
Counsel, at this point, I'm going to ask my good colleagues if they have some questions to pose to you. We have no questions. Thank you.
We'd ask that this court affirm. Thank you.
Mr. Zirkin?
Thank you, Your Honors. Only briefly, of course, I didn't actually get to address the consecutive sentences issue, but I did want to say something about that. The guideline, so Congress's intent is clear that we should not have consecutive sentences for conspiracy to commit an offense and for the substantive object of that offense. Congress required that the guidelines reflect that general rule.
Well, but I'm thinking of our, I guess, Callanan decision and the Supreme Court's Diffenbaugh case. And both our own court and the Supreme Court have held in that case, as I understand it, that a substantive Hobbs Act violation and conspiracy to commit that same violation can be sentenced consecutively. And that seems to me, both from our court and the Supreme Court, to be very, very close to what we're talking about here, where you have a conspiracy and then you have a later substantive act, the later substantive act being the attempt.
It's not later. I mean, that's what distinguishes this case. I agree with the court as to what those cases say, but they are not addressing the facts in this case. The facts in this case are
No,
that
but
they
say
are
it can-
simultaneous.
If they say it can be consecutively sentenced, then it would be a matter of the district court ability to do so. And the question that you're saying that I'm not paying attention, or that those decisions didn't apply to the facts of this case. But the facts of this case seem to be a good one for consecutive sentences in this sense. There's so much time and space between the conspiracy of attempt and the substantive crime, which again is attempt. And the planning for this robbery took place over a year. This gentleman made multiple attempts to recruit an accomplice. After a year, he finally settles on Mr. Brown, who says, well, I wouldn't have done this if Mr. Oliver hadn't leaned on me. And then you've got the Supreme Court saying that collective action poses especially pernicious dangers to society, because these are the kind of things that ought to be sentenced consecutively. And I understand your point, but I feel like that I've got two precedents staring me in the face. And if this, under these circumstances, if conspiracy and substantive crimes convictions can't be sentenced consecutively, I'm hard pressed to think of situations where this kind of conspiracy substantive crime would ever be permissible to impose a consecutive sentence.
Respectfully, Your Honor, that time frame that you've talked about, the conspiracy didn't exist. The conspiracy begins when they are sitting in the car outside of Mr. Fuel, and it is immediate. It is consummated. The conspiracy is created as they're sitting there, and Brown, according to the government's evidence, Oliver keeps trying to get Brown to do it, and Brown says, no, no, no. And finally he says, I'll do it.
Well, we have a conviction, do we not?
Yes, you have a conviction. All I'm saying is, Your Honor, that the time frame that the court said would satisfy why you have to have consecutive sentences, that time frame is not, the conspiracy doesn't exist during that time frame. That is Oliver acting on his own. He's not working with anybody else. There is no conspiracy.
Well, what about all of these people that he tried to, to recruit?
One other person in New York who turns him down. There's no conspiracy there. And if there were a conspiracy there, it's not the conspiracy with Brown. The conspiracy with Brown occurs as they're sitting in the parking lot, and he marches right in and he commits the crime. The conspiracy and the substantive offense are physically and chronologically concomitant. They both are the same time frame. This is the exception to those cases the court has said,
Well,
not that they prove the rule.
I'm still looking at things that, with respect to the Hobbs Act, which says that the substantive Hobbs Act violation, the conspiracy to commit it, can be sentenced consecutively, and the consecutive sentences versus concurrent sentences are something for a classic district court call. And I would think the fact that this individual attempted over the course of a year to recruit an accomplice to bring this armed robbery off would be a permissible factor for the district court to consider in deciding whether to consecutively sentence. This is not a crime that was born on the day that the attempt was committed. It was a crime that was planned over the course of a year with repeated, with recruitment efforts. He had it in mind for a good bit of time. It was the case for concurrence is where the crime is born, perhaps, on the very day that the conspiracy is born on the very day that the substantive crime is committed, but that's not the case here.
I would disagree. It is exactly the case here. The conspiracy was born as they're sitting outside of Mr. Fuel. It doesn't exist before that. It takes two people to create the conspiracy. Mr. Brown is not part of the conspiracy until they're sitting there. No matter what he's thinking about in advance and going through his head, you could do that for his whole lifetime.
That's fine, but that doesn't disable the district court from taking into account, with respect to the conspiracy conviction and the substantive conviction, that a consecutive sentence is warranted. And the reason the Supreme Court says is that collective action is particularly dangerous, which would apply in a situation where both Brown and Oliver were engaged in the armed robbery of this business. And so the concern about collective action is present here, and the degree of time and the desire to bring this off, stretching over a year, would additionally be a reason why a district judge, in his discretion, would say, this warrants consecutive sentences.
Your Honor, when the events happened simultaneously, as the two crimes, that is the conspiracy and the substantive offense, are concomitant, they both happen at the same time, you do not have the circumstances that has led the court to say, the Supreme Court to say that conspiracies have the additional danger of people doing other offenses than that which was originally planned. That is what the Supreme Court case talks about. Other crimes will be committed in addition to the single purpose of the conspiracy, because over the course of time that will happen. There was no over the course of the time in which other crimes could be committed.
Yes, but what do we do with the statement right out of the Supreme Court? District courts have long been understood to have discretion to select whether the sentences they impose will run concurrently or consecutively with respect to other sentences that they impose.
Well,
and the facts here are, with the year-long planning and bringing Mr. Brown into the deal, that would seem to me to be well within a district court's discretion to do what it did.
Understand, Your Honor. Your Honor, I would just note as a final word that the 5G 1.2, which talks about concurrent and consecutive sentences, application note one notes that the total punishment is to be imposed on each count, and the sentences on all counts are to be run concurrently. And it then defines total punishment as, for the purposes of that guideline, it defines total punishment as the offense and the criminal history, and looking at the chart, it doesn't include, in 5G 1.2, it does not include an upward variance as the basis of that.
All right.
Thank you.
Thank you. Pardon me? Okay. I want to thank both of you for what I thought was a very able argument. And Mr. Honold, I know you had to prepare under exigent circumstances, and I want to hope you will carry back the word to your office that you did a fine job. And Mr. Zirkin, I always enjoy it when you argue. You and I get a bit combative, and if you don't want to shake hands with me, you don't have to.
I will fist bump you.
You know, you won't swing. But you're a very able advocate, and I really appreciated your argument this morning. Pardon? Yes, and both my colleagues tell me to express a special appreciation to you for taking on this court appointment. Thank you very much. All right, we'll adjourn court and come down and greet counsel.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.